Hey there, this is Matthew Hill and Carol Ponton with Hill and Ponton on another Q&A session talking about VA benefits. Thanks for joining us. We have a discussion we'd like to have for just kind of some pointers maybe about the new appeal process, the AMA versus what they're calling the legacy. But we're going to just start with some questions and let other folks get here first and probably do that probably not 15 minutes or so. So let's see, the very first question we have is from Shemp Howard. Good day. If I'm already service connected for cervical strain and now have radiculopathy diagnosis, should it be an easy secondary claim or will I need a private nexus?
Well, you always should file the claim because you never know. Yes, they may grant it. If they don't grant it, then you can get a private nexus. But it just depends. It's really funny. You never know who the examiner is going to be.
I would definitely file a claim, let them do the C&P exam first, because they're going to do a C&P exam no matter if you come forward with private evidence or not. Should it be easy? Yeah, it's logical, but as Carol said, you never know what you're going to get there. Chris Hines, hey guys, do you know how long it takes to get an answer from the VA in regards to my claim? It's been about 2 months.
The first question is, where is your claim? If it's at the regional office and it's a supplemental claim, it's really funny. Sometimes I get an answer in 2 months and sometimes it's a year and a half. I'm still sitting there waiting.
And then sometimes it's less than 2 months. So there is no rhyme or reason
right
yet on those. So unfortunately, we don't know, but I have been seeing the majority of them being answered within a year.
But I would say after 6 months, if you haven't heard anything, call.
Yeah, or they haven't asked for anything from you or
said
they're sending you an exam or something. I agree. Eric Seabury, what form is used to file a CUE, clear and unmistakable error, that is outside of the 12-month appeal window? Unfortunately, Eric, there is no form, and it makes it all the more frustrating and convoluted in a way, in that you file that and the VA automatically denies you, saying, hey, you didn't submit new material evidence on this. And if you are submitting a CUE claim, there is no new material evidence you can submit because that's the nature of the claim. So you have to file it on their claim. I put CUE in big, bright colors at the top if you can. And when they screw that up, then you go to higher level review and say this was a Q claim, not a supplemental claim.
Yeah, but you have to attach it to a claim, a supplemental claim, or they won't even respond.
Right.
Okay, and then you write on the claim or with an attachment why it's Q.
Right.
And then they're going to ask you for new and material evidence, and that's when you're going to come back and say it's Q. Okay.
Yeah. So Alonzo Alcon just published yesterday that asthma is now considered as presumptive. What should I do for this? File. It's not a final regulation yet, but you're right. It was published by the VA that they're going to make it presumptive. So go ahead and file today, and that way they'll date it as of today at least.
Right.
Nicholas, to obtain C-file, do you request it from the regional office or submit FOIA? I've seen both mentioned. We submit FOIA. The regional office doesn't have a physical copy of it. They probably have an electronic copy, but I would submit FOIA request.
Right.
Fritz, I was recently awarded TDIU. However, they declined to date it back to when I became unemployable. They said doing my initial mental health claim evaluation, I stated I woke up more than 8 hours a week.
Woke up or I worked?
I worked about more than 8 hours a week. Well, so if it's a matter of whether you worked or not, then you need to look into whether you need to discuss with them whether it was sheltered employment, meaning, it wasn't a competitive environment. You didn't go out open job market and get the job, but you're working for a friend or family or yourself. Even if it's a question of just the law, or they dated it back to basically the date of the TDIU form or the date of the exam, then you need to say it needs to go back to whatever is earliest, the underlying claim that was still going on, or the TDIU, which was still going on.
So if you didn't work, you need to make sure they understand that. And I always ask my clients to get a Social Security earnings record. So the Social Security Administration keeps a record of all the work you've done. So each year it says how much you earned. And if you earned under $12,000 for those years, then you can still get benefits even if you worked. So that's one way of proving when your unemployability began. And like Matt said, you want to go ahead and appeal it because basically a lot of times the VA is going to give you right now because they don't want you to get prior benefits, but you're entitled to them. or they're going to give you the date that you filed the actual form for unemployability, which is not correct either. You need to get back when you stopped working and qualified.
Yeah, that's I agree. All right, CJ, is carpal tunnel a presumptive condition if you filed it only 3 months after discharge? Did the 12-month presumptive rule exist in 91 and 92? Oh, if it's a chronic condition, it could be considered, yes, it could be. I don't know if carpal tunnel is considered under their rules a chronic condition. I think it's 3.38 CFR 3.309 or 307 that lists all the conditions that are chronic, that actually lay them out. So you would need to look into that.
And remember, you have a year from discharge on something like this to show that you still have the condition and it's risen to at least a 10% rating, okay? So if you have the condition, but it wouldn't qualify for a 10% rating, that's not gonna help you either. So you need to prove both.
Laser flavor. I submitted a supplemental for my back with the Nexus letter, and I'm getting a second CMP exam where they will write their opinion. How does this differ from my first exam, and how should I prepare? Probably, it could be same examiner, could be different one. It should be different maybe in that they actually read the outside exam. You know, how should you prepare? I'd just be ready to, if there's, you know, I would take a copy of whatever your doctor said, your Nexus exam. And then I would also be prepared to talk about, you know, what's going on with your back and why you think it's either, I'm sorry, I don't know if it's service connection. Yeah, service connection, why it's, what happened in service, what's going on now, and, you know, did it continue? Was there continuation between the two?
But I would look at why they denied you in the first place.
Mm-hmm.
That's something I'm really seeing, that veterans will continue to file the same thing over, and they realize it doesn't really address the reason they were denied. So did the VA deny you because you didn't have it in service, or you don't have a neck problem? I mean, they may say you don't have a diagnosis of a neck problem, and therefore, you know, it doesn't matter whether you had one in the service or not. Or they will say you didn't have a problem in the service. So pinpoint why they denied you, and then if you have service treatment records that show you had a problem in the service, bring those. If it said you didn't have a diagnosis, bring your medical records to show that. But remember, the examiners, most of them aren't going to take time to look at much, so you don't want to overwhelm them. You want to address exactly what the point is. Yeah.
All right, Rhonda Portis. Hello, I just received notice that my MU condition is static. What does that mean, and what comes next? No need for another exam?
I don't know what MU is.
I don't know either, but it's any condition can be static. Static should mean that it's not going to change. It's not going to go up or down for your.
So the rating would stay the same.
Yeah. So basically, they're saying that it should not go down. Now, you should not have another exam. That this is all kind of the law, but would they send you to another exam? It's a possibility, but the possibility is a lot lower if they're admitting that it's static.
Right.
Mrs. Stephanie, I have 50% PTSD, 10% tinnitus, 20% chronic fatigue for a total of 60. Should I try to get the PTSD increased to 70 to get to 80 in order to file unemployability? Okay, so if you have these disabilities and you were in the Gulf, let's say you were in a war zone, that means that they are all considered under the same, they're all combined together for a rating, for one rating, sorry.
Right.
And if you have a one rating of 60%, then you are already qualified for unemployability. Now, what would I do? I would file for both. I'd file for PTSD increase and for IU. Okay, so you get both those going at the same time.
Yeah, the VA has taken such a strange, you know, all the laws that we have worked with over the years are now in question with this new AMA program. And the AMA program is saying you have to file a claim. Well, before, a claim was assumed if you had a 60% rating for one thing or a 70% combined and you weren't working, it was assumed that they should have investigated unemployability. Now, a lot of people are taking the position you had to have filed a claim for it. So anytime you're out of work and you think you're entitled to unemployability and you're working to get these other things updated or raised, file the unemployability claim.
Agreed. How long does it take for a BVA appeal? That just seems to be going on and on. We don't have a definitive answer. You know, the latest scuttlebutt I'm hearing is that the appeals are going to start getting delayed up to 3 to 5 years again. But that's, you know, that's not written down anywhere. That's just what I've heard informally.
Okay, and here's one thing that I found out when we finally got access to what's going on at the BVA, a very minimal amount of access. But one thing it was showing me is that these are, okay, so there's legacy claims, and maybe this is a good time to go over this, Matt.
Okay.
Okay,
This podcast is being sponsored by AMA versus legacy claims.
all right.
This is the one thing we want to talk to you all about outside of questions. So we'll get back to your questions in a minute. But go ahead, girl.
All right, so the old way that the VA did things is now called the legacy, and the new way is called the AMA. And under the legacy, you filed a claim with the regional office. If you were denied, you filed a notice of disagreement, and if that was denied, you filed to the BVA, period.
But the notice of disagreement was handled by the
Regional
regional
office.
yeah.
Now, under the AMA, you can file a claim. If you're denied, you can file it again with new material evidence. You can go to higher level review
At the regional office.
at the regional office, or you can go to the BVA 3 different ways. No new evidence from the date that the very first person looked at it, not a higher level review or not the BVA. You can have 90 days to put in evidence, or you can ask for a hearing and have 90 days. Okay. I have found that these older cases, the legacy cases that are at the BVA, are being held up because I think there's something wrong with their system. I don't ask for hearings. And on almost every single of legacy case, I found they have noted my veteran wanted a hearing, which means it's being held up. And so these are being delayed far more than they should. I'm writing letters saying we waived it, we never asked for a hearing, and we're waiving the hearing. Nothing happens because it doesn't get in the file. So you need to call and make sure they haven't noted your file as asking for a hearing if you didn't ask for one, because remember they told us if you ask for a hearing, you're going to wait forever, and that's true.
And that's both legacy and AMA. So if you ask how long it's going to be, if you file a hearing 5 years,
Yeah,
it's just you're at the end of a sinking ship. And so you have to have a really compelling reason to file a hearing. And honestly, with all the attorneys in our firm and the hundreds of thousands of cases we've handled in the last several years, I think we've had one hearing, and that was about 2 years ago. So out of the last 5 years, we've had one hearing. It was a reason to go. The gentleman couldn't walk. The board needed to see that. He had trouble using his hands. So that was compelling, but otherwise, we haven't found any reason because it delays.
we found some reasons. Yeah, it delays, and you have married that judge. So from then on in that case, it doesn't matter what happens. You're going to always get that judge unless that judge goes somewhere. And if you end up with a judge that's not good for you, that's a real problem. Okay. But I had wanted to talk about, as we're trying to figure out how this AMA works, because no one really knows.
Right.
Before we always won cases at the BVA. It was seldom that we got a denial. Now the BVA has taken a turn for the worse, and we're getting a lot of denials. So we're trying to figure out how can you get it approved at the regional office, where before we didn't really care because we knew the BVA was going to grant it. And one of the things that I've just learned, so you file either a new claim or a supplemental claim. And if you're denied, then you can file for a higher level review. Well, I've found that we're winning about 20% of the higher level review if I find that they missed a duty to assist.
What's duty to assist?
So a duty to assist, thank you, Matt. A duty to assist means that once you've sent in a reasonable claim, the VA must assist you in evaluating that claim by giving you a compensation and pension exam. So once again, look at the decision and figure out why they denied you. I am finding that in many of my cases, they never gave them a compensation and pension exam.
Or got records that the veteran said, hey, I need these records for my claim. VA is supposed to get them, didn't get those.
Exactly. And then you need, remember, find out why they denied you. Did they deny you because it was service connected or because it wasn't a diagnosis? I had one that said the veteran doesn't have a diagnosis of hypertension. And so I resubmitted to the higher level review all of his medical records showing he had hypertension and he was granted benefits. They sent him out for a new compensation and pension exam.
I was going to say, when she said resubmitted, one of the keys to understand is that the higher level review, you cannot submit any new evidence that was not or should have been considered below. So what Carol's saying is that the evidence existed when the first exam took place, and the evidence was there, first decision took place, and they just ignored it. So Carol could resubmit that, but otherwise,
and usually I put it in,
cannot.
I can put red rectangles around it, and then I point out all the times that he was diagnosed with hypertension. So, or sometimes you have filed a claim and you've asked for say you've asked for sleep apnea, and they only evaluate it as to whether or not you had it in service. But you're saying my sleep apnea is secondary to my PTSD or my mental condition, and the examiner never evaluated that. They will give you a new exam to evaluate just that. And just with that, I'm finding that over 20% of the cases are now being granted. So you get a new CMP exam. Sometimes they don't even do a new CMP exam, they just grant. So I wanted y'all to look at that because one thing I find is a lot of veterans don't know why they're denied. And if you don't know why you're denied, you're not going to be able to help yourself get approved. Okay.
And if you look at the decision, at the end of the decision now, it should say what's called favorable finding. So again, if it's sleep apnea, you know, the favorable findings are, let's say, have the diagnosis.
Yes.
Nothing happened in service. Okay. Or, you know, have the diagnosis. So now what you need to prove is what it's related to. And as Carol said, a lot of times you're not saying it's related directly to service. You're saying it's related to a secondary condition, PTSD, diabetes, something like that. So it's good to look at that part of the decision, and that helps you realize, okay, this is what they said. And once they say it's favorable, they can't take that back,
Right.
which is a great thing. So that's something to look for.
Hearing loss is another one. They will say subject to noise in service. So that's proven. Okay, what is it that they didn't say? Did they say you don't really have a qualifying hearing loss? So read that decision really well. That's how you're going to win.
All right, back to the questions.
Back to the questions.
All right, commercial breaks over. JT, 12-year Navy veteran, bad motorcycle accident, is in the ICU. Any benefit information I can pass along to his wife? There's no VA service-connected compensation there if this is 12 years after. There's nuances. This one right here. There's nuances if he had something. Well, no, somebody else turned out in front of him. So I don't think there's anything there. If there was some way that a service-connected disability, you know, if someone turned in front of him and his reflexes were impaired, meaning he'd been service-connected for a TBI or some kind of peripheral neuropathy or something that didn't let him respond as quickly, possibly, but unfortunately, there's no benefit I can speak to right now.
Except, does he mean that he's still in there and he just had an accident?
What do you mean by that?
Well,
still in service.
If he's still in service.
Navy veteran.
Oh, okay.
I don't know. So sorry, JT. I think from the looks of your question, unfortunately, I would say no.
But anytime somebody's in an accident, it's really important to find some way to memorialize what hospital he was in and see if you can get those records and keep them, because he may end up with a traumatic brain injury. He may end up with headaches, all sorts of things where he could have hit his head, but he really demolished his leg. So the more all the attention's being paid to the leg, but in the future, the real problem he may have is from something else that happened in an accident. And a lot in the VA, a lot of times they lose those medical records, especially ones from hospitals.
Right. All right. Robert Ramirez, have you ever had a case where the VA took away service connection after 5 years? They're claiming service connection was in error, no fraud. This happened after a routine future exam. Yes, I believe the fraud doesn't kick in. Does fraud kick in under service connection?
Yeah, the only way
10 years.
The only way is fraud. If you show fraud, no, the service connected has to be 10 years, and then the only way you can get rid of it is fraud. But are they saying there's Q? That's my question.
No, he's saying that he went to an exam,
and they're saying it's not service connected,
right? Even though he had service connection for 5 years. They still, I think they have to show error, but they have to show it to a higher degree, and not
much higher degree.
Previously it was considered this diagnosis, and now it's this one. Well, is that a progression? Is that the same thing? They have to. Did they forget? Sometimes I do see where they say the prior determination did not have any service records that are relied on, and there was no way to show service connection. So it depends on what they did it for. But yes, I have seen that, and you can fight that. And if you have the evidence, that showed proved the prior claim, then you should win.
And I've noticed at the regional office, they often don't use the law correctly.
Yeah.
So you want to go to the BVA. That's the first place you're going to hopefully find people who will follow the law. So anything like that, you're probably not going to win at the regional office. You're going to have to go to the board, but make sure you understand why they're saying that and that you have the evidence to overcome that. It should be their burden, not yours, but that's not usually the way they do it.
Right. Let's see, living in Mexico, if I have an open BVA appeal and I file a claim for an increase for SMC level, would the SMC claim still be processed in the special ops lane, or would it possibly go to the core lane? I'm not quite sure if you're talking about the BVA appeal, like the different levels, or if you're talking about the RO. If you have appeal number 1 is at the board, and then you file claim number 2, the claim number 2 is still going to go through the regional level process, and then you can appeal to the board after the first claim if you want. But they will go through different processes.
Is he saying he's in Mexico, the country?
Well, he's probably living in Mexico.
I know, but what I'm saying is they process those claims differently somehow.
Oh, well, that's a different regional office.
Right.
Yeah, that's right. So it would probably go to that regional office, but your first claim should have gone to that regional office as well. Okay, Nicholas, denied service connection for hyperthyroid, but just got a letter from my military treating PA saying it's his medical opinion that he missed the diagnosis. How credible is this for the VA? Just filed something. Yeah, I'd say
I would think it's very credible.
And then that is the evidence you need, hopefully not only to reopen, but to win.
Right.
All right, Noah had service records for both sinusitis, service-connected rating, and service records for rhinitis. Should I file for rhinitis as well, or will they see that as stacking? I'd file for them both, but if the symptoms overlap and there's no distinct symptomatology that you rated on different issues, then you're not going to get rated for it, but it doesn't hurt to file for both.
Because you don't know which one is going to get the higher rating.
Right. All right, Frank, what paperwork is needed for an appeal for a caregiver program? Thanks, BVA. That is through the Veterans Health Administration, so you have to go through the hospital for a caregiver. I
would think you'd still use the same information though that you're using in your case to show that you need aid and attendance. You need someone to help. So anything that you develop for that, I would use for the caregiver as well.
Yeah, so right, the evidence is definitely overlapping. The form, I would speak to a VSO in a hospital or a clinic about getting that form.
Because we don't have those.
Yeah, look that up online. John Gold, 100% rated. I am livid. A VO neuropsych eval just accused me of not having a TBI and malingering after years of medical documentation. How can a vet fight this false accusation? Rated 40% for TBI. Mr. Gold, I sympathize with you. I mean, if you've been fighting for this for years and you finally get the proper rating, there are bad docs out there. I mean, there are people that try to undercut veterans, especially when they're outside the VA contractors. They make their living with the VA, and never seen this in writing, but is it better to find more for the VA or find more for the veteran? That's what I always wonder. So how can a vet fight this false accusation if it's not reducing your rating, if it's not affecting?
Well, he's saying it's not service connected. Isn't that what he said?
I think he said
malingering. Why?
Yeah.
So
well, he said he's 100% rated already. Not having
not having and malingering after years of medical. Okay.
If it's affecting your rating going down, then you need to appeal it.
Right.
And how do you fight it? You say, you get a copy of the CMP exam, see what he said versus what's reality for you. And I would write a letter saying, this is what I said in the exam, and this is what he documented, and this is not true. Attach any medical records you can. That's what I do. Now, if it didn't affect your rating and it's just some jerk CMP examiner, I know this is hard to stomach, but I just leave it alone.
I wouldn't, you can leave that alone, but what I would consider doing is you can write a letter to the medical head for the VA and to your congressman or your senator. They care about this, and tell them what this doctor did. And I have had doctors being jerked from being employed by them because they have gotten enough letters from people to realize there's a real, a systematic problem here, and we're going to get rid of it. And so I wouldn't, if this doctor really did something you think is not right, then I think you should write to them and let them know exactly why. And if they try to set you up with this doctor again, refuse to go and say, this doctor did not treat me fairly and I want another doctor. Never go back to them again.
I'd go with her. All right. Let's see. Fritz again. I don't have your prior question here, but it says, to be clear, my previous question, I forgot to mention I'm self-employed. When I received the TDIU, since the examiner stated that I worked 8 hours a week, they denied my appeal. What should I do?
8 hours a week.
Give me a break.
Yeah,
should
give me a
appeal.
break. That's what I'm saying. Get your social security records and show you didn't make any money.
Well, and the fact that you worked for yourself.
Right.
You need to just write a letter saying what you did for yourself. If you had employees where they were doing the work for you, if you were doing the same job for someone else, meaning like, I don't know, you were a carpenter working for yourself and you're working for somebody else, would they keep you on? Would you have the stamina to come in, day out? That's the clarification.
If you worked 8 hours a week because you had to lay down or rest most of the rest of the day, you need to clarify exactly what was going on.
Appeal it. Lucy, so today when they were to re-review my deferred, not denied PTSD and depression claim, so now they deferred it another 16 days. This is the 5th deferral in the last 3 months. Dang, who hates me? That's a lot of deferrals. I won't lie. I mean, usually I've seen 2, maybe 3 when they get clarification from the CMP examiner. I don't know what they're doing here. I'm gonna be honest. That might be worth a letter saying what's going on here. You know, can I get a decision? I'm sorry to see that. That's frustrating.
Yeah.
Shankia Richardson, hi. I appealed my initial rating for lumbar strain in neurologic.
Which one are you reading?
I think this is basically a ridiculous thing.
By neurological, and one
Diagnosed changed from 10% to DDD stenosis 40% with no effective date.
I'm not sure what you mean by neuralgia. 40% is
Usually the most you can get for your back, unless your back is frozen, ankylosed, that doesn't move. The rest you get that for pain going down your legs, for instance. So you need to figure out, they should have, if they gave you 40% just for your back, and you do have radiculopathy, and that's what you're calling neuralgia, then you should appeal it and say what you think they didn't give you, but say, I'm not appealing my back rating. I'm only appealing the radiculopathy that goes down each leg. So, you know, I don't have this decision, so that's my best guess.
Yeah, I agree. Noah, I was told by my veterans group handling my claim for increase that recent application for obstructive sleep apnea with CPAP was given 30% instead of 50% for secondary sinusitis. Any feedback on why? The VA wants to change the regulation on, or the rating and how it's rated for sleep apnea because they feel like they're giving away too much money. It has not changed yet. So if you have a CPAP, the rating code says that you are entitled to 50%. If they, put 30%, it's not beyond the VA to make mistakes or to be, say make mistakes. So I would definitely appeal that. I think it's incompetence. You ask why, or just, not paying attention to what they should have, looking at the actual medical record showing what you need as far as CPAP. JT, granted IU in March from the date I applied 8940 in May 2019, but my 4192 states I stopped working in June of 14 due to service-connected disability. Should I put in an NOD? I think that's hard. A couple things have to happen. You have to have been at that level for the more
The rating
straightforward,
level.
for unemployability back when you weren't working, but you also had to have had a claim going back then, and you have to have that claim has to be active now. So they can't, the law says they cannot go back to either prior to a claim being filed in this circumstance. So if you had a claim filed back then for any of the disabilities and you continue to fight it, then yes, there's a chance. If you haven't, even if you weren't working that whole time and you frankly deserve the unemployability, you cannot get it under the law. All right, Terry.
Once again, file for unemployability as soon as you stop working, no matter if you have the ratings.
Or if you're working for yourself or working
Yes,
for a friend.
and if you're not making $12,000 a year, file it.
Terry 15, what would be a reason for a deferral in INBS, irritable bowel syndrome claim? Seems pretty cut and dry to me. I think we talked about it a little bit earlier. Essentially, if they want a clarification from a CEP examiner, that is the most often time I see it. And again, I lost my spot. Okay, here we go. Let's see. CJ, I have had 3 comp exams in the same claim. First exam was by QTC, outside examination company. It got lost in cyberspace. The second was redone by QTC, and then the VA scheduled a third with LHI 4 months now. Okay, so I would that's frankly, that's incompetence on their part. It's frustrating. So you just got to hang in there, unfortunately. Noah, served in 2 branches of the military, have records from my last term of active duty in the Air Force. How would I acquire medical records from my first term in the service? You can either file a SA 180 with the National Archives and ask for a copy of all your service and service medical records, or you can ask for a copy of your claims file, which VA should have gotten those records already and associate them with your.
I do both.
Yeah, because sometimes what the VA got is not a complete copy. Okay. If I got 10% for tinnitus, can I add vertigo secondary? Sure, apply for it and see what happens. When I was denied unemployability because the doctor made an error on my paperwork, was reinstated for my service connection, can I apply for unemployability again? Yes. Mm-hmm. Frank, what does permanent total mean for 100%?
Permanent total means that the VA says they're not going to review you again. And so you probably don't have to worry about it, but that doesn't mean that they can't review you again. If for some reason, say your neighbor says I'm reporting you to the VA, there's nothing wrong with you, then they may look at it again. Okay, but with most ratings, the VA puts a review date when they intend to send you out for a CMP exam. If you're granted permanent total, they don't do that anymore. So there shouldn't be any CMP exam.
And you're also entitled to a lot of secondary benefits, healthcare for your family, dental eye care for yourself, and
college for your kids.
Oh yeah, college for your kids is huge. And then a bunch of other little things. You can go to your state and see if you can get property taxes taken off.
Either total in Florida,
yeah,
and a certain percentage in California. So it depends on what state you live in.
Yeah. Andrew Green, I forgot to put headaches on my VA claim, but tinnitus and various other things cause it. Is this going to be an issue? I would at least write a letter clarifying, say this is part of my claim. This is one of the symptoms of my claim. I think I'd say that.
Yes.
This is one of the symptoms, headaches, and go from there, because then they might rate you just under the headaches diagnostic code, versus if you put in a new claim, they're going to say, oh, this is a brand new claim for
so that. Clarification of claim 4, tinnitus, whatever else.
Yeah, or just say it's a symptom, a letter saying these are the symptoms of what I just claimed. Ernie Moreno, do you have an office in Los Angeles? We have a satellite office in Los Angeles, and when we do go to a hearing, or if we need to meet with a client, we will go there. It's not it's not a full-time man, but it's something we have in case we need to see somebody. We typically can get everything done through the over the phone, computer, fax, and so to cut down on costs, we try not to travel that much to keep things.
Everything is handled over the internet. I hate to say this, but I don't think I've ever met a veteran I represented unless I have to know them beforehand. We do it all because we do it across the country. We do it across the country, and we don't meet them.
Yeah, I mean, we talk to them on the phone.
Yes, on the phone, email.
Love yourself. Hello, I have a question related to an Afghanistan veteran who severely suffers from PTSD and TBI with seizures. He needs help with 1, VA disability pension and benefits, and 2, legal help in court. So when you say legal help in court, if it's like a state court, we can't really help you there. VA disability pension, it seems like if he has those PTSD and TBI, a pension is based on income or age, whereas what we're talking about is the VA benefits
that are service connected
or show that it's related to service. So if he does not have that and they're both severe, he needs to get those service connected, because unfortunately those are the poster child wounds of this last war, and TBI with seizures indicates to me that is a very serious disability. So he needs.
So compensation comes from something that's service connected. Pension, if you serve during time of war and you are unable to work, that's what you have to show there. But there's a limit, there's a financial limit. So, and it's like $1,200 or something a month. I don't know exactly is. And there's a deduction for every other. The most you can make is $1,200. So if you're already getting Social Security at $1,200, you're not going to get anything from the VA as far as money. And that's why the compensation is so much more important, because you're going to get $3,100 And if he needs aid attendance and help because of the TBI, he could get a lot more than that.
Yeah. Okay, Reginald, I'm rated 70% for mood disorder, major depressive disorder, excuse me. Can the VA reduce my rating because medication is helping my disability? That's questionable. They could, if you're doing exceptionally better, then sure. But that's not something we typically see. I would still be recording whatever it is symptomatology wise you are dealing with, because if you're feeling better one day, that doesn't mean you're
Right.
feeling better the next. So that's what I look out for. Is hemorrhoids can be a service connection? So can you be service connected for hemorrhoids? Yes. R. Taylor, VA keeps denying hypertension service connection. Service treatment record indicates untreated blood pressure levels of hypertension levels, including a compensable blood pressure. So you need a doctor, I think, at this point, if they're still denying that, just saying,
Yes.
hey, look, this is the onset, or this is the beginning of hypertension.
I'm giving you, you are diagnosed as having hypertension in service.
But
Because that's a
even-
chronic condition.
You're right, but even if you weren't diagnosed in service, if you
No, he
had
can-
the manifest or had symptoms,
Right.
then I think that.
But if you
it's a-
have the 180 over 90 or something like that, you already show you have that. And what he didn't have was a diagnosis.
Okay.
And
Yeah.
so if you can go back and say, this was hypertension,
Right.
this date, this date, this date, then that's going to help you a lot.
Okay.
But you need a doctor's opinion.
John Thompson, TDIU form 21-8940. When employers ask how many days employee missed due to disability, does this work against the veteran if employer does not know and enters none for the number of days? I'd rather them enter I don't know.
Yeah.
I definitely wouldn't want them to enter none. Timothy Certain, I have sleep apnea and have PTSD, but tried for a nexus and was told obstruction mechanical and would not win. Is that true or not?
Told them.
So he's saying it's a physical obstruction versus due to the
I'd appeal it.
the mental.
If you have the same symptoms, I don't understand why it wouldn't work.
Yeah, that is one that I've seen the VA win on, but it's something I agree with Carol. I fight it. Porfiero Espalda, I have a 40% disability and I'm waiting on a decision for my tinnitus exam. They told me at the VA that service connection can add to the 10% to the rating I already have. So if you get 10% for tinnitus, which is the max rating, and you have 40%, here we go on math again.
It's going to go up to 50.
Yeah, it's gonna go up to 50. Your rating would be 46% and they'd round up to 50.
So your combined rating, right?
Yeah. R. Taylor, is there a recent pattern of ignoring Nexus or IMO? I have some that were not used in claims. I see, especially the regional office, ignore them all the time. So if you've submitted one, continue your appeal. Frankly, it's almost better if they ignore it at first, because then you can argue above saying, look, they screwed this up. As Carol said, at higher level review, sometimes you can go, they didn't even look at this, and hopefully get your benefits there. Vincent, I was involuntary discharged from the Navy 11 years ago for failing physical assessment, too bad. I developed depression. How can I prove that? I think you need an outside, it's going to be an outside exam where you need a doctor to say, because of this incident in service, which is documented, you failed and couldn't get re-enlisted, that made you depressed because you wanted to be continue in the Navy, but that's going to be hard.
It's a hard claim.
Yeah.
And you also are going to need statements for people who knew you before and after service saying how you were before, but you were really depressed when you came out because of that. Those statements are going to be crucial. But you have a hard claim.
Yeah. Noah, should HLR and supplemental claims be filed ahead of new claims, or should they be able to file at the same time? They're handled by the same departments or separate departments. Okay, so let's break this down. So this goes back to what Carol was saying. What I'm going to assume here is that you have a claim that was denied. If you have a claim that was denied, we have three options, but if we're going to stay in the regional office, you can ask for a higher level review, looks at the same evidence, a more seasoned adjudicator, and just reviewing what was done to see if it was wrong. Or you can file a supplemental claim on the same issue, but you have to have new and relevant evidence. Okay, so you can't do both at the same time, but you can do one or the other. And if they deny you with higher level review, then you can file a supplemental claim with new evidence. So there's an option to do either. As far as which office handles which, there are St. Pete out of Florida and Seattle, Washington are the two places that handle the higher level review. All the other regional offices are dealing with supplemental claims. So those two offices are considered, specially.
But once again, figure out why they denied you. And that ought to help you decide, do I need additional evidence? Or have I got everything evidence all in and I'm going to go to the higher level review and then up to the board. So that's really important.
Yeah. Rakeem, can I submit a fully developed claim and supplemental claim at the same time? Or would submitting a supplemental claim knock the fully developed claim into standard claim? So this is where it's just so confusing with this new system and how they've done it. If you have to, unless you filed a claim before. If you've never filed a claim before, then you're filing an original claim. But if you filed the claim before, it's a supplemental claim. Even if it's fully developed, it still goes through that length.
So if you've ever been denied before for this issue, then you have to file a supplemental claim.
Lucy.
And just so you know, sometimes when veterans come to me, I file a number of claims. I'll file some 526s because I feel like they should have these things, but they've never filed. And I'll file supplemental claims because I feel like they shouldn't have been denied other claims. Okay, so it doesn't hurt to have all these going at the same time, if that's your question.
Lucy, thank you. It's nice to know I'm not crazy. Just another Vietnam vet getting screwed over the VA. Hang in there. Don't let them push you out with their waiting.
Welcome to the VA world.
Well, I'm sure you've been there for a while.
Yeah.
Elma, why is it taking so long for increase in PTSD to 100%? We don't know your specific circumstances. It's pretty hard for a straight 100% for PTSD. Yeah,
very hard.
It's hard to show that. We handle almost exclusively mental health claims, and most of the time, what we end up doing is getting a veteran unemployability due to a PTSD, because if it's that bad, there's no way they can keep a job and not be able to get a job. But as far as maintaining one, that's something usually always happens, and so that's where we go. But it's hard to get straight 100.
Yeah, very hard.
Shankia Richardson, okay, thanks. The bilateral neurology was not rated, only my back. Also a major depressive disorder denied service connection. Do I file new claims to request secondary condition? No. So if it's related to your back, you file, like Carol said, a higher level review and say they considered a direct service connection, but they didn't consider related to the back. Okay. Rob was given 100% P&T last week from a claim filed in May 2021. They gave me back to May 21. I originally applied in June 2015 for the same stuff and was denied. Can I get back pay, and how? That 2015 claim still must be active. Usually the easy answer is no, you can't. But if they screwed up, if you got a rating decision and then they received within a year some kind of new evidence, a new letter from you
related to those issues,
related to you, or you saw somebody in the VA medical center due to those. At that point, you could just say, hey, this claim is still pending because you never considered these that were within the.
Or if they sent the copies to the wrong representative, there's certain legal errors we look for, but most of the time, if you haven't continued the appeal, it's dead. But those are some of the things you can look for.
Yeah. Timothy Certain, if I cannot work and want to do TDIU, but did not talk to my job because of PTSD, will they deny me for not saying anything?
No.
It's really a medical evaluation. Getting information from your work does come into it a little bit, but really it comes down to what does the doctor say about, CP doctor say about your ability to work.
I didn't want anybody to know, which is clearly you didn't.
Lamar, how do you fill specific things? I've seen foot condition percentage and flat feet. Sorry. Foot condition percentage and flat feet percentage for both, which resulted in 4 separate percentages, all primary. I'm not.
I think I think it's It's due to whatever the problems are. Do you have arthritis in your feet? Are they flat? Are they deformed? Is your arch totally gone? I mean, I think you have to definitely state all the problems you have with your feet, and they come under different ratings under the foot. So you have to look at that. That's the best. I'm not really sure of the question, but that's the best I can do.
Yeah. Blue Cord Delve, seeing the VA requiring employees to get JAB, and I'm seeing other hospitals requiring it also. Any chance of VA trying to require those of us on disability too?
JAB.
I'm assuming that is inoculated, or what do you call it?
For COVID?
COVID. I saw that the VA was imposing all its employees get immunized for COVID, but I don't know what JAB is.
I don't either.
I think it'd be pretty hard for them to require veterans to do that. I don't really see how they do it.
I don't know, Matt. They're
Requiring to get it or lose their disabilities. Well, yeah.
not lose their disabilities, but I think maybe they could say, I don't want you coming in.
Oh,
I think that
yeah,
might be a
yeah,
possibility.
as far as
To
medical.
lose your benefits, I don't think that would be at all.
Okay. Kilo Alpha, I was treated for acid reflux 8 months after exiting military. Is that a presumptive, or can I get a claim as service connection? If you were in the Gulf, you could claim that as Gulf War syndrome, or show that it's related to your service in the Gulf. If you weren't, I don't believe it's presumptive. But
No, I don't think it's presumptive. It depends on how bad it was, maybe to say it's within the year that it has reached the 10% rating. Okay,
yeah, that's hard case.
that's a hard case.
Stephen Nichols, VA told me they sent my C-file in the mail on a disc. I never received anything. What do you recommend to do? Stephen, I'm not quite sure. I know we answered many questions earlier, but I would tell them I want to send it again and send them your address again.
Yeah,
because
confirm with them the
yeah,
address that they're
make sure
using.
that you're sending it to the right place.
Yeah.
Ray Evels, I am service connected. I have service connected degenerative arthritis left knee. I've had meniscus surgery on my left knee. Can I file for the meniscus surgery? Yes. Damian Wallace, awesome job. I'm 20% for my back, 10% for mild foot drop, but my x-ray shows arthritis in the facet.
Mild foot drop is a 60% rating.
Yeah.
There's no mild
I was
foot
going to
drop.
say that's like kind of pregnant.
Yeah.
Yeah, you should. Do I file for? I'm sorry, I cut off the question. Do I file for an increase? Yes, you should be
Absolutely.
getting
You
a lot more.
So what you need is you need to go get one of the, or at least I hope you have one of the braces, an AFO, and that keeps your foot level so that it doesn't drag when you walk. And that will help prove to them that you do have foot drop, that the VA thought your problem was bad enough that they gave you this brace.
Yeah. Okay, Alan Goodman, don't have a question. I just saw you live. Wanted everyone to know that Hill and Ponton took great care of me.
Thank you.
Thanks, Alan. Not an easy case. Got me up to 100% working on back date. Appreciate it.
Thank you.
It's nice feedback. Alex S. My CMP examiner didn't document everything I told her on the DDQ, and as a result, I got underrated. Can I file a supplemental claim with a private DB2? Yes, you can, or you can do what Carol said and go to the higher level review and say, hey, this is what I told her. This might be questionable.
I'm always over the top. I always have my veterans, I take a statement from them about these are all the errors that this person did.
Right.
So that it's clear that they weren't fully evaluated. If you've got a doctor who will do the DBQ, do that. And once you do that, they're going to send you to a new CMP exam. That's the crazy part of the duty to assist. If there's no evidence, they do nothing. But if you put in good evidence for yourself, a duty to assist comes up and they'll send you to a doctor. So make sure you cited all the problems there were with the original one. You put in good evidence that you have yourself. And then hopefully the new doctor will see, if I don't write everything, this person's going to complain. So I would take both of those things with you when you go to the new CMP exam.
I'd consider filing if you have access to a doctor, that's phenomenal. I'd consider filing what Carol said as far as the errors they made, list those out as your new evidence. And if that kicks you to a CMP exam, then great. But then if the CMP exam is negative, then I would file the good exam. And that way, I always like to have my exam last, meaning like my doctor had the last word on whatever was said. and they can critique what the VA said, because, you know, the chances of you getting a phenomenal doctor in your CMP exam coming up, not that great. So
Great.
so-
Okay, I'm going to go with him.
yeah, I mean, you know, that's kind of in the weed strategy, but that's what I would look to do. All right, Leo Rodriguez had TDIU CMP yesterday. Doctor said I was definitely worse and should not be working. Will TDIU go back to the original filing date? It'll go back to, okay, it should go back to the original filing date of this claim flow. Now, what we've seen the VA do a lot, especially the supplemental examiners, is they will give it to you either the day of the exam or
Yep.
even the day of the rating decision, which is totally bogus. So you would need to file an appeal or higher level review saying, I filed this on this date, you know, and go from there.
And
But
this condition has been the same
yeah,
since I filed.
It's ridiculous. I mean, they basically are creating more work for themselves.
Well, what they're trying to do is, I'm going to give you this and see if you go away.
She's more jaded than I am. All right, Daniel.
Well, what else? Give me a reason.
Daniel, let's see. You're currently getting med boarded after 25 years, fighting with my PA for a diagnosis. Will I be okay if I'm getting medication but not diagnosis? For example, for treating for a GERD. Yes, you do not have to show diagnosis in service. You have to show that something happened. You have to show that something happened through evidence in addition to your statement, in addition to what you said. Okay, so the fact that you're on that medication and that medication is specifically for GERD, then yes, I think you have a good chance there. Joseph, I've been rated by the VA with 50% PTSD and have been diagnosed with sleep apnea. How can I use sleep apnea as a secondary claim? Can you help? I would, well, good.
You just file a claim for sleep apnea secondary to my mental condition. And then there are articles all over the internet. You attach those articles and then file the claim. Unfortunately, the regional office, I have seen 2 cases approved out of hundreds, but the regional office is usually not very sympathetic. The BVA is more so, but I always have a good independent medical exam at that point. I don't rely just on the medical treatises.
Okay, so Joseph, I've been rated by the VA with 50%. I just did that one. Sorry. Rendleman's, I am TDIU permanent total. I have an other than honorable discharge. Wonder if you handle discharge upgrades. We do not. There a lot of law school clinics will. One that I recommend is Stetson in Florida, out of St. Pete. I think they have a wonderful clinic and they do a good job. But if they're not, you know, willing to do it, I would look at other law schools, because that's kind of it's you know, close to what we do, but different enough that we just don't specialize in that.
And I would pursue that because they're much more favorable now than they were years ago. And you really need to put the reasons, what happened to you. You were young and what happened, okay?
Jerry, I have a private doctor. Are there nexus letters that I can show him to assist in writing for me? If so, where? I don't know about that. Sometimes VSOs have forms, but basically for a nexus letter, you need to show that that doctor needs to see the service record, service medical record from service, buddy statements, whatever you have anchoring the issue to service, the diagnosis now, and the doctor needs to say why what happened in service is related to this, and then give a reason. Okay, just this is the medical literature. This is why, blah blah blah. So you would that's something I would look to do. It doesn't have to be long or fancy. It just has to be well reasoned. And in you providing the evidence of what happened in service, and you know the medical records have shown whatever your diagnosis is, and then he has to provide what's in between.
So, but I see that disregarded if you don't have the service medical records.
Yeah.
So make sure you get a copy of your claim file. And then the doctor says, I've reviewed the service medical records, the treating records, and I've examined the veteran. And it is my opinion that it's more likely than not that the veteran is service connected for this condition, because that's basically the format of what you need.
Kinty Horton, will there be a rating given for people that have COVID-19, being that we don't know what side effects may come from it? Doesn't matter if it's 0%. I think the VA actually is trying to figure out the ratings for this, trying to figure out how they can rate this. This is going to be a problem, I think, where vets go to the VA hospital and they pick it up from somebody else, and there's what's called an 1151 claim for that. I haven't seen the regs yet, but I've heard that they are in the middle of making those. But you're right, just getting a 0% rating is good in this situation, because if side effects do come up. you can just look at an increased rating versus having to fight the whole service
And
connection.
remember what COVID does, it suppresses your immune system and makes you more likely to catch certain things or to become ill with certain things. So that's always an argument you can use as well.
Okay, we are at the fire round here. Let me try to look at some folks I haven't spoken to yet. Okay, M&M Motives, 53 years old, stuck abroad 10 months now due to COVID Delta variant, 90% rated, want to file IU. You can file online, right?
Yeah, you can file online.
That's what I would do. Mark Keeling, I have been waiting since March 5th for them to get something from the archives. How long has this taken?
Oh, the archives have been closed because
Yeah,
of COVID,
because of
and
COVID.
the backlog is awful. And I would resubmit, because I don't know if they're going to go back and look at all these old things, or they're just going to pick up with the new stuff. It's a mess right now.
Yeah. Ed Dickman, sorry if this has been asked. I just noticed you're on. If my family doctor won't write a letter or do a DBQ, how should I proceed with secondary claim for GERD, sleep apnea, and ED? I mean, the first thing you want to do is tell the VA you think they're secondary to whatever the service-connected issue is, and get a C&P exam. And then with the examiner, you just want to kind of walk through, hey, this is when these things came on. You know, I already had this, and this is how it all walked in. Otherwise, we don't really deal with those issues that much. I would contact somebody outside. If you're 53, that means you could have served in Gulf War I. So I would consider, you know, if you served in Gulf War I, I'd also make those a Gulf War claim. Mr. Gee, what if you have past claims denied, and after review you saw the doctor check no to one of the questions states, did you review veterans record? Well, goes back to what Carol said earlier. I'd write a statement up saying they didn't even do this right. They didn't even look at my records. How can they give you an adequate opinion?
Right.
And go from there. Sam G, how important / helpful are spouse statements in a PTSD claim? I think they're incredibly important, because with PTSD, we found again and again that vets kind of have blind sides as far as how their actions affect others, and how what they might see is not that
Bad or normal
or yeah, it might be normal
or acceptable.
Other folks do not see it that way. So I think this would be incredibly powerful. All right, let's see.
As long as your spouse feels free to write what's really happening.
Right.
Don't read it. Let them feel free to do that, because if you're going to temper down what's going on, you're not going to get the rating you deserve.
I honestly, when I have my vet and spouse on the phone on these, I say, I want you to write, if he's an asshole, you know, I want you to write about why he's an asshole. And then I tell my veteran that, hey, I don't want you taking offense, because this is actually what helps your claim. So sometimes they hang up on me, but that's what you need. You need complete honesty.
I know, because if you're going to not say what's going on, why, you know, you're not going to get your claim rated right. You need to let them be honest.
All right, filed in 2017 was denied. Lawyer filed again in 2020 in no back pay. That's common. We're seeing where they, well, if you did not appeal the 2017 case, then you're probably not going to get back pay. But if you know if you filed on Jan 1, 2020, and they awarded you, you know, June 2020, then that's something you need to appeal. Furry full. Why wait until age 55 to apply for SADI? Thanks from Scott. I don't know what that is. I'm thinking that's Social Security.
I think you're
Social
trying.
Security disability. Yeah. I don't think you need to wait if you're not working.
No. Why are you waiting?
Yeah,
As soon as you're not able to work, you're disabled and can't work, you should file the claim. I think what they might be saying is they have a chart, and people who are 55 and older have a much easier way of winning than people that are under 55. But that doesn't mean that you can't win. And I find that even though the Social Security judges have become incredibly hard, they are softer to veterans. They realize what veterans have been through, particularly if you can show PTSD or things that they're aware of.
Mm-hmm. Okay, Kyle, can GERD be connected to PTSD? Sure, you're going to need opinion on that though. Yeah. CBR, OS, sleep apnea secondary to service-connected tinnitus denied with medical nexus letter from board certified sleep doctor. Completed sleep apnea DBQ and buddy statement.
Okay, remember at the regional office, they don't want to award that. You've got to go to the board.
Well, I mean, I consider the higher level review.
Higher level review first,
but yeah, don't put in you put in great evidence.
Right. So
don't go down that road. If higher level review denies you, then go to the board. Tony for since Sanders v. Waite case, would it be possible to link chronic lower back to no longer use sit-ups? I did these for 30 years in the Army, and I'm sure it's the cause of my low back pain. I mean, I think, yeah, again, that's an incident service. You're going to need an outside exam no matter what, but that's an incident service you can do. Shed, she, it's not a very good name, sorry guys. When filing supplemental claim for 70% for major depressive disorder, should or can court decisions be included with documents?
No.
They're not going to look at it.
Yeah, they're not going to look at it.
Is that the law? Yes, but they're not going to look at it. Now, if you're at the board, you could
Yes.
say the name of the court case, and it's almost like a shot over the bow because they know, okay, this guy actually knows some of the law. So yes, but at the regional office, no. John 4, recently rated 100% for physical conditions and over 70. Is it worth the file for other conditions? You could possibly get special monthly compensation S, which is another 30%. I'm sorry, $300 or so a month, but you'd have to show that one of these disabilities is 100%. So
I think it's worth it. You know, you and I differ on this a lot. I think SMC can, under SMC, some people get $9,000 a month, not the $3,100 or $3,300 for 100%. So you should look at the SMC is one of the most complex things the VA has ever done, but there is money out there. So if you have erectile dysfunction, that's one SMC. If you have 100% for one thing, including it could be unemployability, and you have 60% in combined ratings for another, that's another SMC. If you need aid and attendance, you need someone to help you with the activities of daily living, now you're up into the 4,000 a month. So you need, if you can't really balance or walk on your feet, that's big money. So you really need to figure out, do you meet any of these? And if you do, it could be well worth your while. If you don't, no, it's a waste of time.
okay, just a couple more. Lady T, the headache from this is literally killing me. They screwed me so much. I'm like, just kill me, please. I'm sorry that you're going through that. It's just awful that you have a disability you're dealing with, and on top of that, you have an incompetent administration you're dealing with as well. That's making it worse. But if you think the rate is related to service, then I would, I'd keep fighting, and I know it's got to be hard while you're fighting those headaches as well. I've been waiting.
Try and see if you can get the headache service connected. Do you have depression that you're claiming? Do you have a neck injury that you're claiming?
Secondary is what she's.
Make them secondary. Make them pay for it.
Teddy, I've been waiting 99 days after my hearing, still no answer yet.
That's typical.
That's the VA. Jerome, I think I'll give you the last question here. What is VA's duty to assist error? I'm at a higher level review, and VA said they made an error. Because of this, I have to go to another exam. Can I refuse to go to this exam?
No, you don't
Well,
want to.
it says I'm 100% P&T. I was told that I can't. So,
Well, why
my
are you going
question
to
is-
an exam in the first
well, maybe he followed your advice and he wanted to try to get more.
place? SMC is totally different though.
Well, okay. So if I would drop the claim personally for whatever they're trying to send you to.
If you're
if-
permanent in total, why are they
Yeah,
sending
they
you?
shouldn't be sending you anything. But if you filed a new claim for, tinnitus or something, and they're sending you to an exam for that, then I wouldn't go. I mean, I would just say I'd scratch that out.
Okay, but what is he going for? Are you permanent in total for major depressive disorder and they're sending you to exam for tinnitus? Then you can go. But that's what I was saying earlier in the program. I have found that with 20% of my cases, I'm able to win them at the higher level review only because I pointed out a duty to assist, that they failed to examine the case in the way that they should. So you need to figure out why they're sending you there.
Yeah. Sorry, we didn't have more information, but usually they're sending you another exam and you got to go. If you're already permanent total, then you have choices there, I think.
Well, if you're permanent in total, they should be sending you to an exam for something else, so it seems like.
Right.
Which wouldn't affect your permanent total. We always agree, Michelle.
Well, on that note, I hope everybody has a great rest of your day and rest of your week. Thank you for joining us. Thank you for these great questions. And we hope to see you back here next week.
Don't give